I believe we are still waiting for one of the judges.
Yes, we are. My mic will be a little bit quiet till I start speaking, just so you know. Uh-oh, we're losing people.
Steve, do you know if Grady Lynn will be joining us as a judge? Okay, we'll give the other judge just a little bit more time to join us.
Okay, it looks like we should have him here shortly.
Great, thank you.
We are thriving, guys. Can you hear me?
I can, but it looks like we've lost Miss Stahl.
Yes, we can, Grady, although I think we lost Jennifer, one of the judges.
Okay.
If you could,
Well,
if you could just hang on for a moment. It looks like she had a problem with her app, and she'll be joining us in just a moment.
volunteer. Before we jump into the debate round, let's kick ourselves off with a few introductions. Hi, my name is Luke Castle, and I'll be affirming the resolution today. Thank you all so much for taking your time to judge. I really appreciate it.
I'm Nathaniel Morgan. I will be your negative speaker. And like Luke said, thank you so much for coming out here.
Now, before we start our debate round, it's really helpful if we know just a little bit about our judges. So do you want to share some of your past judging experience, past debate experience, or maybe a couple judging preferences to make sure that we cater this round specifically to what you want to hear? Let's start, if you don't mind, with Mr. Leaderhall.
I'm happy to go first. My name is Tom Lydorf. First of all, congratulations to Luke and Nathaniel for making it all the way to the finals. Well done. I am looking forward to sound reasoning and credible evidence in today's round.
All right, thank you. And Mr. Len, you're next on my screen.
Absolutely. I will echo the congratulations to make it to finals. I did a decent amount of LD in middle and high school in STOA. And for me, it's important that you don't spend much time on arguments that don't matter for the resolution. Tell me the 2 or 3 arguments that are most important for the resolution, where you disagree, and why your side ought to win that. And that's what will convince me in the end. But other than that, just have a good round.
All right, thank you. And Ms. Stahl.
Yes, thank you. I am an attorney here in Oklahoma City. I coach debate and mock trial and other forensic events on the side. And I actually agree with both of Mr. Lydorf and Grady's judging philosophies. To sort of elaborate on something that Tom said, whenever you're citing evidence, I appreciate just like a healthy relationship with evidence, which is to say, if your opponent states that the Eiffel Tower is in Paris, don't ask them what their source is for that. I've judged both of you in the past. I don't suspect that either of you will abuse evidence in that way, but on the flip side of that, I appreciate citations and I appreciate knowing where your information is coming from. So good luck to both of you and congratulations for making it this far.
All right, and Nathaniel, I'll echo that congratulations as well. If y'all are ready, let's start with the first speech. All right. Imagine for just a second that there's a 4th person in this call with us. I'll name him Jonathan. He's a thief who just got out of prison. He turns on his webcam and starts ranting about how wrong it was that he was in jail for 20 years for just one small bank robbery. Frankly, no one would sympathize with Jonathan because Jonathan violated someone's property rights and Jonathan got punished for it. Because the simple fact that people have an inherent right to property rings true in this debate round, I affirm our resolution. Result: protection of intellectual property ought to be valued above open source innovation. Let's start by framing this debate round in 2 quick definitions. My first definition is that of intellectual property, which is defined by Oxford as, quote, a work or invention that's the result of creativity, such as a manuscript or design, to which one has rights and for which one may apply for a patent, copyright, trademark, etc. End quote. Now, my second definition is that of open source, which American Heritage Dictionary defines as, quote, open to public participation as in the sharing of information, end quote. Here's the conflict. Protecting intellectual property means that we recognize people's rights to control their creation, even if they're giving it away. Open source innovation means that people give up control of their information and release it completely into the public domain. Now, I've got 1 point of resolutional or topic analysis for you. Go ahead and write it down on your flow as enacted by government. Now, there's only one actor that's capable of changing the standards on intellectual property, and that's the government. No matter how hard a business campaigns for intellectual property, unless the government sets a standard, it's unlikely to be followed on a mass scale. I'm not saying to ignore businesses and the private sector, but we do need to focus our discussions around the largest mover and shaker in the resolution. So looking at governmental policies and governmental obligations. Now that we're all on the same page, we need a value or a way to decide who wins this debate. My value is that of the right of exclusion. Now, the right of exclusion is defined by James Stern, who's a professor at William & Mary Law School, as, quote, the right to prohibit one or more persons from using a particular resource, end quote. The right to exclude is really simple. It says the rights holder gets to decide what happens with the item. We use it all the time. When your kid comes up and says, hey, can I borrow your phone? Regardless of your answer, you're exercising your right to exclude. You're exercising your control over that possession. Now, there's two reasons I want you to use this as the value in our debate round. Go ahead and write down that first reason, or my first value link, as essential to property rights. Thomas W. Merrill, a professor from Columbia Law School, tackled this issue in the 1998 Nebraska Law Review. Quote, "The right to exclude others is more than just one of the most essential constituents of property. It's the sine qua non," which is just Latin for something that's absolutely necessary. Give someone the right to exclude others and you give them property. Deny someone the exclusive right and they do not have property. End quote. Think of it this way. I can tell you that you own your pen as much as I want. But if I don't recognize your right to keep Nathaniel from taking all your pens and using those to flow the debate round for him instead, I don't really exercise or recognize your property right. Here's the second reason to use this as our value. Moral imperative. Now, any moral system first has to prioritize fundamental human rights. John Locke defines human rights as life, liberty, and property. Let's focus on that last one. Remember, if we don't have the right to exclude, we don't have property rights. If a government said you have the right to buy and own a house, but also we're forcing you to allow anyone into that house, you wouldn't really own a house. My parents can lend me their car, but I don't have a right of ownership to it because I can't exclude them from using it. In 1776, Americans were forced to quarter soldiers, violating their property rights. So in the Third Amendment, we said this was no longer acceptable. These reflect how a culture that values basic human rights must put the right to exclude first. If we don't, society will crumble. So now that we know we're measuring the resolution, let's set about proving it true. I'll have two contentions for us. Go ahead and write down my first contention as open source innovation ignores the right to exclude. Definitionally, open source hates the idea of the right of exclusion. The idea of open source is everyone owns everything and no one really owns anything. Remember, it's defined as freely sharing information. But that goes directly against the right of exclusion. Let me illustrate with an application. Application number 1, Oreos Big Soap. No, I'm not a fan of Oreos, and before you kick me off the call, let me explain why. Olivia Henry, an economic socialist, wrote an article on June 8th of 2018 to detail how the Oreo concept was actually stolen by the producers. You see, the Oreo was actually called the Hydrox, and it was created by a pair of brothers in New York. And in 1884, they decided to make a cookie with 2 layers of chocolate and a cream filling that they debuted in 1908. Now, when they debuted it, people loved them, and so did a company called Nabisco. In 1912, they invented the Oreo, which was the same exact product. But because they didn't have an exclusive right, Nabisco owns the patent and the millions of dollars. We can't have open source innovation and the right to exclude, as having a right to exclude makes open source innovation impossible, and open source innovation always inherently violates the right of exclusion. So here's my second contention. Intellectual property upholds the right of exclusion, or protecting intellectual property upholds the right of exclusion. Now, in that same law review, Thomas W. Merrill covered how the intangible rights, such as intellectual property, are related to the right of exclusion. He writes, quote, "The law with respect to intangible rights and intellectual property is, if anything, even more striking to the degree to which property rights and the right to exclude go hand in hand." End quote. In fact, this issue was brought before the Supreme Court in 1984 in Ruckelshaws versus Masanjo Co. And the Supreme Court ruled that the United States would continue to recognize the intellectual property as having a right to exclude. I don't have a specific example for you, because protection of intellectual property isn't something that we put in the news. Millions of people create ideas, patent products, and start new lines every single day. Businesses prosper and go on to do great things for society. But if we don't value the right to exclude, we can't value property rights. If we don't value intellectual property, we can't value property rights. Let's stick to the status quo and stick with what works. Valuing intellectual property allows society to function.
All right, you ready?
I am.
Okay. Let's go to the important stuff first. Let's talk about the Oreos. So first off, was the Oreo, the predecessor to the Oreo cookie, was that protected by a patent or no?
No, it was not.
Okay, so it was basically open source innovation at that point.
No, it was open source innovated by Nabisco.
Yeah, that's what I meant. Okay. So did they break the law by doing that, or did because there wasn't a patent, or
well, remember, they didn't explicitly break the law, but intellectual property doesn't require there be a patent on it. Intellectual property is just a work or an invention that can be patented. They still violated intellectual property.
But you would agree that in order to protect intellectual property, we have to patent it, correct?
That is the typical way of doing it. I suppose we could convince everyone to never open source innovate, but patents are a little bit more effective.
Okay. Can we agree that open source innovation is something that you voluntarily enter into, right?
Well, we have a governmental actor, so that would make that impossible.
Okay, so you think that the government should be forcing people to, or do you think the resolution is calling for the government to force people to open source innovate under a negative ballot?
Well, I believe it has to be enacted by government, as I talked about in my resolution analysis.
Okay, so does the resolution say promotion of open source innovation or enactment of open source innovation, or just open source innovation?
It says protection, which would be implemented by the government. I mean, businesses can't.
Okay, I'm talking about the open source innovation term. So are you saying that it's the protection of open source innovation that's under the resolution?
Well, I'm saying that protection is a general term. It sets.
Okay. So are you saying that the protection of in the resolution applies to the open source innovation?
I think protection is framing the resolution so we can understand it better.
So it's not just protection of intellectual property. I want to be clear here. You're saying that it's the protection of open source innovation as well?
Right. I believe that it asks us to contrast protecting intellectual property and protecting open source innovation.
Okay, thank you for clarifying that.
Sure.
In open source, but yeah, so can we agree that in open source innovation, at least if the government enacts it or promotes it or protects it somehow, in that model, it is voluntary. Like people decide to give up their ideas for free, right?
Well, I would say if the government's enacting it, then they wouldn't really have a choice. I don't think.
Okay, well then let's step away from the government enacting it for a little bit and just look at it how it works in the real world right now, because the government isn't forcing everyone to open source innovate. In that context, if a decision like a business decides to use open source software or proprietary, they're choosing to give up their ideas in open source, right?
Well, the majority of people choose open source because intellectual property is impossible.
Intellectual property protection is impossible?
Right. I mean, look at things with a huge crowdsourcing foundation. You can't really have 1 million people listed on the copyright. So a lot of people choose to open source innovate because intellectual property would be extremely difficult or impossible.
Interesting. And lastly, could you send me the evidence under your contention 2 talking about how intellectual property protection is upholds the right to exclude?
You mean the law review?
Yes, that one. I'll be taking prep time as he sends that to me, and then I'll get started. How are you planning on sending it?
Give me just a second. It won't allow me to attach my PDF, so I'm going to have to find the link for you.
Okay. You know what? I'll just I'll refer to it if necessary in the next speech, but I'm going to go ahead and get started so I don't have to use any more prep time. I have 2 minutes and 19 seconds remaining. As this is a 7-minute speech, I'm going to assume that my judges are ready. If for whatever reason they're not, then just let me know. But I'll go ahead and get started. Now, the fundamental flaw in the affirmative team's case is that he's not only valuing something that is not the most important thing in the debate round, but he's analyzing this resolution all wrong, with no regard to the wording here. The resolution says protection of intellectual property ought to be valued above open source innovation. He's saying that protection of is generalizing it to open source innovation as well. But I fundamentally disagree with this, and that's my response to the enacted by government resolutional analysis. My response is of government can't open source innovate. If the government decides to use open source innovation in its own sector, then that's fine. That's what we're talking about in the resolution, as well as individuals, businesses, and everyone else. What we're not talking about is the government forcing people to get protection for their intellectual property and forcing people to open source innovate. That's not an educational or fun debate to be happening, and that's not what we're talking about according to the wording. Now, if the resolution did say protection of intellectual property ought to be valued above the promotion of open source innovation, then that would be different. But that's not in the resolution. Because there's no specific saying protection or promotion when we're applying to open source innovation, the grammar here is not on Luke's side. My second response to this is of model versus model. The most educational and the most reasonable way to be weighing this debate round is weighing the model of where we protect intellectual property, where individuals get their intellectual property protected by the government, I will concede, or the model of using open source innovation, where the ideas are free to access and we can actually benefit from them. That's what we're talking about in the resolution. Let's address his value now. His value was of the right to exclude. My response to this is going to be my response to his contention 2 as well. Legal right, not a moral one. Now, the difference between intellectual property as a right and property rights is very nuanced, and they are not the same thing. They don't fall under the same category. As the Legal Information Institute, writing for the Cornell Law School, says, quote, "The law of intellectual property is separate and distinct from the law of tangible property. Whereas the right of exclusive possession is at the core of the bundle of rights protecting real and personal property, land and chattels, the same cannot be said of intellectual property," end quote. So intellectual property is something that we choose to protect as a right that we give to our citizens. It's not a human right or a right that we are entitled to by virtue of being alive, like normal property rights are. The reason for this is because intellectual property is not tangible. The idea behind what you create is not tangible. Someone else can come up with that exact same idea, whereas that's not true with property rights. So his value here is it doesn't have any moral strings attached to it. So my response to the moral imperative point is of not a human right. Therefore, his entire case fails because it's predicated on the point that morality comes highest. Now that morality is not coming highest, we should be looking at what benefits society most. And for that, I present my counter value. You can write it down, is of spread of inventions. The reason for this value is twofold. The first is in my value link, the end goal of creativity. The reason for innovating and coming up with ideas is to share it with other people. Otherwise, society doesn't benefit. And my reason to prefer this value is of gives maximum benefit. The more people have access to these ideas, the more benefits our society as a whole can reap therefrom. If we just allow people to protect their intellectual property and not allow other people to benefit from them, that's a bad thing. As Jeff DeGraff writes in 2015, and by the way, he is pretty credible. He's a professor, author, and speaker, and advisor to hundreds of the top organizations in the world on the subject of innovation. And he says, quote, "The proliferation of open access platforms has redefined the notion of intellectual property. This means that ownership is not our end goal. Rather, it is the distribution of creativity as opposed to the singular concentration of it," end quote. Now that we have a choice between open source innovation and protection of intellectual property, the goal is not to protect everyone's right to own what's in their mind. The goal is now to promote what's best for society as a whole, and that's upheld under a negative ballot. Let's get into contentions that prove this. My contention 1 is of open source spreads inventions best. Subpoint A to this is of public reaps the benefits, or the public reaps the benefits of free access. As Jeff DeGraff writes in 2015, once again, quote, "This is the mindset behind today's open source movement. Unrestricted access to designs, products, and ideas to be used by an unlimited number of people in a variety of sectors for diverse purposes," end quote. Why is this important that we allow ideas to be spread and cross-pollination and using one idea and bringing it to another sector for the benefit of society? Well, my subpoint B into this is of the impact. Together, we are stronger. As Mark Hinkle, writing for Wired in 2013, states, quote, "The beauty of open source is that it's a huge ecosystem of innovators who are no longer competing for scarce resources, but rather sharing knowledge with others to create new resources and opportunities for others to benefit," end quote. Under the Affirmative team's world, profit-hungry individuals develop products and charge high prices for non-ideal solutions to our problems. But the customizability and the real workability of open source allows us to bypass that and be beneficial for society as a whole. So that's why it's better. But contention 2 is going to address how intellectual property fails this. Intellectual property bars the spread of inventions, or you can write down IP bars the SOI. Subpoint A to this is of inhibits ease of access. Under the world of the affirmative, individuals who want to use an invention must consult the owner for permission. The owner will likely charge a fee or make the user give credit for the idea. This system hinders rather than helps the spread of ideas. And my subpoint B under this is an application of how it supports injustice, or actually, in some ways, protecting intellectual property when it goes too far can be immoral. And my application is of Monsanto. Now, Monsanto is a giant agricultural tech research corporation. They engineer GMO soybean seeds that aren't susceptible to pesticides. In 2013, a farmer named Vernon Bowman bought some of these patent soybean seeds. And a couple of months later, the Supreme Court fined him $84,000 and on a 9-0 decision ruled that he had violated patent law. His crime? He harvested the seeds from the plants that he planted. I'm not even kidding about this. Because the seeds were the same genetic makeup, even though he had grown these new plants himself and put time and resources into it, he was technically violating intellectual property law. This is what happens when we affirm the resolution. Big companies win lawsuits against individuals who are just trying to benefit from the inventions they buy. But open source solves this by allowing for free access. That's why it's better. In response to his contention 1 about open source ignores the right to exclude, my response is of voluntary. You see, open source innovation is people voluntarily choosing to give up their ideas for free, and oftentimes it's a better model, as I've shown. In response to the application of Oreos, my response is of no patent. This is not protecting intellectual property here, and they weren't doing open source innovation either. Open source has licenses that make it so that you can't take an idea and then patent it afterward. And I already responded to his contention too before, so thus his whole case fails and my case stands and upholds the side of spread of inventions.
I've got 3 minutes on the clock if you're ready.
I am ready.
All right. Once again, congrats on finals. Would you say that property rights are important?
Oh, yes.
Would you say they're a foundational right?
Yes, life, liberty, and property are human rights.
So you'd agree without property, society would basically turn into chaos.
Yeah. If without property, we wouldn't really have a society. Like, I don't know how I would have a house or anything.
Do you think it's more important to protect, say, foundational human rights over things like making new inventions?
Well, making new inventions in some ways can uphold foundational human rights, but I think human rights are very important, yes.
If they're in conflict, we choose rights over making and spreading inventions.
As I already proved, intellectual property is not a human right.
Okay, but if human rights and the spread of inventions are in conflict, we pick human rights, correct?
You know what? I'm not actually going to answer that because spread of inventions is inextricable from human rights itself. If you were to somehow extricate it from having no human rights implications, then yes, I would say yes. But I don't think that's true.
So you don't have a position on whether or not human rights or the spread of inventions are more important?
No, I just gave you my position. If you can somehow separate human rights from spread of inventions, which I don't believe you can, then yes, you should use human rights.
All right, great. Is it possible to have property rights without the right of exclusion?
Let me think about that. The right of exclusion is a fundamental right that has to do with property rights.
Okay, so
I don't know. I actually don't know if it's possible to have it without it.
All right, so could we agree with Thomas W. Merrill, the famous lawyer, that we would need the right to exclusion in order to have property rights?
Well, when you have a property right, I think the right to exclusion is part of that. Because when you own something, you have the right to exclude people from that. That's your right to your property. It's basically the same thing.
Nathaniel, just to clarify, if we take away the right of exclusion, we take away property rights.
Well, they're the same thing, so yeah.
All right. Now, you brought up some evidence about Monsanto. Could you please send that evidence in the chat when we're done with cross-ex?
I didn't actually read any evidence. I summarized some, but I can bring you evidence. I bring up evidence later on if you want it.
Evidence would be great. Can we agree once you give ideas away, you can't really take them back and protect them?
Usually you can.
Usually, so if I tell everyone in the world a piece of information, I can just go take that information and hide it again.
Well, if you put it on the internet and nobody decides to look at it, then you can take it down. So,
but
no, if you literally give it to everyone, like put it in a mailbox and put it on their doorstep, then no, you can't get it back.
All right, and can we agree that protecting ideas upholds the right of exclusion?
Protecting ideas?
Yeah, that protecting ideas would uphold protecting ideas would uphold the right of exclusion.
No, I cannot agree to that.
So you don't think that controlling our ideas would uphold the right of controlling ideas?
No, that's not your question.
Do you think that controlling ideas...
The right of exclusion is different from the controlling ideas.
All right, no further questions. I'm going to go ahead and take 3 minutes of prep starting now.
I just sent the evidence and a link to it.
No further prepping necessary. 1 minute and 31 seconds on the clock. Moving. I'm gonna go and put 4 minutes on the clock for first rebuttal if y'all are ready. Good to go?
Yep, looks good.
All right, let's get started. Now, before I review my opponent's points, I want to launch into the two main arguments I'll be drawing throughout this debate round. I'll be focusing on the right to exclusion, why it's absolutely necessary and is a moral imperative. And secondly, I'll be focusing on intellectual property, why it's the only way to obtain the value we'll be using at the end of this debate round. But first, let's refute a couple of points. He brought the idea about how governments can't force open source innovation. My response is that of only enforcement. Now, businesses have used open source innovation off and on, as well as different organizations for quite a while. But we're discussing when we have to choose, when there is a conflict between the two, which is most important. Now, as my opponent conceded, the government is the only one who can protect intellectual property. The only conflict between those two can be if the government wants to protect open source innovation. Therefore, we need a government actor. Next, he talked about it's a legal right, not moral. My response is moral obligation to uphold. That was a long tag. It's moral obligational to uphold. Now, I already talked about we have a government actor. They're the lens we're viewing these things through. Now, governments have an obligation to uphold basic human rights, life, liberty, and property. So they have a moral obligation to promote the right of exclusion, as it's necessary to have property rights. It is a moral right. Next, he brought this idea about how there's a difference between physical and intellectual property, especially referencing the right to exclusion, and they have different rules. My response is Supreme Court disagrees. In fact, in 1984, the Supreme Court specifically ruled there is not a difference between the two, and both deserve to be constituted as things which you should have rights to property over. Now, next, he talked about spread of inventions. I'm going to have two responses here. Right, my first one down is forsaking morality. Now, I don't have a problem with spreading inventions. That's great. I think having new webcams and new hoodies is amazing. But when we have to sacrifice the basic right to property in order to obtain that, I don't think it's a worthwhile trade-off, which is my second response. Secondary concern. Look, we make money after we do what's morally right. Doing what's morally right is protecting the fundamental human rights. That means that we have to make money later after we protect them. He next brought up this whole idea about how that intellectual property, or I'll respond to that in just a second. His first contention was open source innovation spreads innovations the best. My response is that it removes rights. It does remove rights in the process, so I think that's valuable. Secondly, no true warrant. Apple, for instance, is all intellectual property. Windows is all intellectual property. Those are the major share of the computer market when Linux is open source and isn't really being effective. So I think there's a pretty major difference, and he needs to warrant this argument because it looks to be false. Next, he brought up the idea of how intellectual property is the basis of spreading of inventions and how it inhibits the ease of access. You can group my response with this whole idea about open access reduces IP with the idea of CC 3.0. Remember, open source innovation is totally free sharing of information, and intellectual property is regulations over the sharing of information. You can still give away stuff that you control underneath intellectual property. You just license it. It can still be free, but you retain the copyright, so you can control or decide to distribute it. He brought an application of Monsanto. My response is that of selling reproduced seeds. This application sounds really bad until you read the rest of the story. The guy was taking that product and copying their makeup so that he could try to take over Monsanto. He was using second generation seeds and selling them as official products, taking away from their money and violating their rights. Finally, he talked about no patent with Oreo. My response is that of meets definitions. It meets the definition of intellectual property and open source innovation. So that's not really a viable argument. Now that we've taken care of those two things, let's move into those voting issues. Write down the first one as right to exclude. I'm going to have 3 subpoints. First, foundational. The right to exclude is foundational to property rights, which is a moral obligation. Second, moral imperative. My opponent was never really able to address these two issues, but we have a moral imperative to do what's right and holding property rights. Finally, conceded. My opponent conceded protecting rights is more than the idea of spreading inventions. Impact, use affirmative value. We need to use our value because it's conceded and still holds true. Second voting issue, intellectual property. Now, I brought up legal review, which was never really refuted, saying that the United States and Thomas W. Merrill both recognize intellectual property as upholding the right to exclude.
Okay, I'll be taking the remainder of my prep time. Okay. This is a 6-minute speech. I'm going to assume my judges are ready. I'll get started. When we look at this debate round, there are really 3 fundamental issues, and all of them actually point toward the negative side. The first of these is talking about the government conflict, or what we're talking about this resolution, and I'll address that now. You brought up the only enforcement point, saying the government is the only people that can protect intellectual property. My response is of conflict happens with individuals. If the government is the only one that can protect intellectual property, and individuals are the only ones who can engage in open source innovation, then we have no conflict here. The conflict happens when individuals go and get protection from the government or support protection of intellectual property, or when the government or when they choose to use an open source model. We're talking about these models here, and I think that either way you look at it, this is how the debate should be weighed. And the second issue is about whether or not intellectual property is a human right. Now, I believe that this is fundamentally flawed, and Luke's misrepresenting what the Supreme Court said. If you listen carefully to the evidence he read in his first speech, it didn't actually say the Supreme Court said it was a human right, but rather that people have a right to it, or that it's intrinsically tied to it. Now, I'm not saying that intellectual property rights and property rights are not this. I'm saying they're not the same thing, but I'm not saying that they aren't tied together or they don't share some similar things. But as the experts that I've read from the Legal Information Institute, Cornell Law School, said that there are different areas of intellectual property. I mean, there are different areas of the law of intellectual property is separate and distinct. The reason for this is because intellectual property is not a human right. I will quote an expert on this, Farida Shahid, who's the UN Special Rapporteur, who's analyzing what the United Nations as the world says are human rights. And she says, quote, "There is no human right to patent protection," end quote. Patent protection is literally protection of intellectual property. There is no such thing as the human right to intellectual property. So thus, morality is not at stake in this resolution. Now, Luke is going to come up and say, oh, it actually is at stake. I've read some other experts, that this guy at the law school and the Supreme Court said that. When he does that, remember this. The Supreme Court did not actually say it was a human right. And secondly, this is more important, is the U.S. is not equal to the world. Look, the United Nations has recognized that intellectual property is not a human right. Property is a right. It's a fundamental right, but intellectual property is different. If it wasn't different, if they were the same thing, then why do patents only last for 20 years? Why do you have to petition someone else to actually get your rights protected because you can't do it on your own? That's not true for normal tangible property. Like, for example, if I pick up this thing on my desk, right, there's only one of these. I can't duplicate it, right? Because there's only one physical, tangible object here. That's not true for intellectual property. You can just copy it because it's an idea in your head. That's why it needs to be protected under the affirmative team's world. So now that I've shown you how it's not a moral imperative and it's not actually the right to exclude should not be our highest value in this debate round, let's talk about the spread of inventions. And this is my voting issue 1. You can write down is of spread of inventions best. This is the value you should be using in the debate round because, as I alluded to in cross-ex, even the spread of inventions has moral ties to it. It's the government's obligation to provide for their citizens, and this responds to his first voting issue. Spread of inventions is inherently tied to morality. By choosing the best model that results in the most benefits for the most amount of people, governments are upholding their job as being moral. So the spread of inventions, so subpoint A to this voting issues of spread of inventions gives the maximum benefit. As I said in my first speech, which hasn't really been contested, he just said there was no warrant. I read evidence for this, and I gave you plenty of warrants. The reason why it gives the most benefit is because it allows for free access. This is inherent to the idea of open source innovation. Subpoint B under this is of provides for citizens. It's the government's job to provide for the citizens in the best way as they can. And when they do an open source model is promoted, then that's actually what happens. And the impact of this is of a better model. We should be using open source innovation because, as I said in my first speech, together we are stronger. If we use open source innovation as a model, then we are allowed to actually give people access to things that they need. And this is inherently a good thing, and it's actually a moral thing, and this is how we uphold morality through open source innovation. But now let's turn to intellectual property protection. And my voting issue 2, intellectual property protection fails. Now let's talk about my application under my voting issue, my contention 2 about Monsanto. He's responded by saying selling seeds. Now this is actually false. I don't think he looked in depth in the article that I sent him. My response is of using the seeds, not selling them. Look, he was technically violating intellectual property law. I'm just saying that kind of a law and that kind of overreach and infringement is a bad thing. And because, I mean, the Supreme Court ruled on a 9-0 decision that he had violated the law. I'm just saying that that law was unjust because that's what intellectual property protection does. What he was doing here was he was using the seeds. He planted the seeds and then he grew them up and then he took the seeds from the new ones and tried to harvest them again, right? But Monsanto didn't want him to do that. They wanted a monopoly. They wanted him to have to go and get more seeds from him instead of using what was best for, or the most efficient way to grow seeds and stuff like that. In other words, they wanted to just get money from him. I'm not saying it was legally, technically, yes, they could do that, and that's why they find him, stuff like that. But what this goes to show is how intellectual property bars the spread of inventions, and it doesn't allow that to happen, which is a bad thing. The impact of this voting issue is of supports injustice. As we can see here, intellectual property is not a model that works. It doesn't allow for the free flow of ideas and the spread of inventions. Spread of inventions is inherently high, the highest value in this debate round because, one, it has moral ties. It's the government's moral duty to make sure that its citizens are provided for. And secondly, because, as I already proved, intellectual property is not a human right. I read experts who quoted on this, and I've already taken down his analysis here. Right to exclude is inherently not the best value for this debate round, and thus we should look at the system that promotes spread of inventions best. And that system is open source innovation.
I have 1 minute and 31 seconds of prep remaining. I'll take a bit now. All right, 3 minutes on the clock for the final affirmative rebuttal, if y'all are ready.
I'm ready.
Now, before I jump into the direct refutation, I want you to remember those 2 voting issues I brought up in my last speech. If I win those 2 points, I'm going to ask for your ballot. Now, to refute a couple of ideas, he started with this conflict happens within the individual. My response is conflict through government. My opponent conceded that the only person who can enact intellectual property is the government. That means that the conflict has to be between the same actor. The only conflict that can happen if the government is truly the only one who can uphold IP is for the government to be recognizing open source. However, I don't think this majorly changes the decision, so we'll just move on. He next talked about how intellectual property isn't a human right. My response is that it upholds human rights. Now, I made this big deal about how I was supposedly misquoting a Supreme Court thing and claiming that it said it's a human right. I never said that. But the Supreme Court did rule that the idea of intellectual property falls underneath the right to exclusion, which they deem to be a necessary component of property rights. So they do get there and they do claim it's human right. They don't explicitly say it, but they say intellectual property is a key part of upholding property rights. This was basically unnegated. I next talked about the spread of inventions as the best. My response, and we'll just look at a couple of the subpoints. He first talked about allowing for free access. My response is non-unique. You can give away something that you keep underneath intellectual property. You just use an IP license that doesn't require you to pay something. I brought this up in my last speech. He never refuted it. Next, he talks about provides for citizens. My response is non-unique. Intellectual property also provides for citizens. It's what created 97% of the computers that you use versus the 1.63% that Linux created. It also provides for citizens, and this isn't a benefit that's unique to his side. Finally, responding to the idea of intellectual property fails, and he tried to support this once again with Monsanto. My response is check the article. He sent it to all of us. Look at it, because the article specifically says he used those seeds, quote, solely to mark and recreate the product, end quote. He was only using it to make and market the product, and that's why he was sued for it. Read the evidence yourself. You don't have to take my word for it. He finally talks about sports and justice. My response is false. If this application's wrong, there's no real warrant, and I ask you to not consider that. Now let's take that, let's remember what we said there and move into our 2 main voting issues, proving why you're voting affirmative at the end of the debate round. Going right down that first voting issue as right of exclusion. Now I'm going to have 3 subpoints. First, foundational. My opponent conceded that you have to have the right to exclude in order to have foundational property rights. Secondly, moral imperative. We have a moral obligation to uphold these ideas and moral obligation to uphold basic property rights. Finally, conceded. My opponent conceded in cross-examination that we should use this value instead of the spread of inventions. Impact, use affirmative value. Since he's conceded it and because it holds true, we have to decide this debate round on one question. Does intellectual property uphold the right to exclude? If it does, we're voting affirmative. My second voting issue, intellectual property. I brought up legal analysis, and it hasn't truly been refuted that intellectual property upholds the right to exclude. For the Nebraska Law Review, the Supreme Court, and every logical time. Here's what I'm asking. Are values the right to exclude, and intellectual property upholds it? Please vote for that case. Thank you all so much for judging. I really appreciate it.
Great job, Luke. That was really fun.
Well done to both you guys. Congratulations.
Thank you.
Great round.
Thank you so much.
Great round to both of you, and I'm going to get started on my ballot now.
Awesome.
All right, great. I look forward to reading it.